Okay, we're now officially recording. So, welcome to our second Global Lawyers of Canada virtual mentor office hours. We're very excited tonight to bring you two criminal defense lawyers from here in British Columbia. We have an ITL, which is an internationally trained lawyer, which is Mitchell Fogel, and we have a homegrown Canadian lawyer, Leeanne Footman, going to be talking tonight, sharing with you their experiences, their journeys, offering some tips, and hopefully answering some of your questions, because I know nothing about criminal defense law. Everything I know is from watching TV. So I'm hoping these guys are going to teach me a little bit tonight as well. So I'm going to hand it over to Mitch first to introduce himself, and then we'll head over to Leeanne next.
Okay, great. Well, thank you very much for having us. We're really excited to be here. I know Leanne and I were texting today and sorting out our wardrobe and everything, so it's been a lot of fun to get excited and ready. My name is Mitchell Fogel. I am originally from Ottawa, and I've had a little bit of a interesting journey to make it to Vancouver and be called to the bar. I originally did an undergrad at Dalhousie University, where I studied psychology and philosophy, and then graduated with a double major in arts and lost a little bit of passion for some of the psychology stuff and going through and becoming a doctor in order to be able to practice there, and sort of realized that at the time the philosophy aspect wasn't necessarily leading to a lot of professional jobs with only an undergraduate degree with it. So I went back home to Ottawa and worked a little bit in an unrelated field, and then decided to go to the UK to do my JD, or my LLB, sorry. And that's when I went to Sussex University in Brighton, and I did an advanced program there where I studied for 2 years and then came back and did the LLM-CL program at University of British Columbia for 1 year. And through a contact that I knew actually from the United Kingdom, another student and friend of mine, she had been working at a criminal law firm here in Vancouver, and so she told me that they had needed a student, and so she kind of helped me to get my foot in the door a little bit, and I interviewed with them, and then I articled there at a firm called Myers and Company, as it were. And after that, when I finished, one of the partners at Myers and Company decided that he wanted to start his own firm with one other established lawyer, and the two of them asked me if I wanted to join them as their junior associate. And so I thought that that was a great opportunity, and I decided to do that, and that's where I practice right now. So I have been called to the bar for about a year, and I'm practicing at a firm called Ferguson Allingham, and it's a really great place. Check us out online. We've got a fancy website and a nice little bio. And in a nutshell, that's it. I know we've got a lot more questions about that, so maybe I'll just leave it there and pass it over to Leanne.
Great. Leanne, over to you.
Okay, so my name's Leeanne Footman. I am a criminal defense lawyer as well, obviously, here in Vancouver. So I did my undergrad at the University of British Columbia. I'm originally from Ontario. So I came out here for undergrad, and then I was doing political science and international relations. My focus was mostly on nonprofit work. I worked for a bunch of nonprofits, Invisible Children, Feed the Children, basically anything to do with children. So that was kind of where I was headed. And then I went to the University of Toronto Monk Center to do my master's degree in international relations. And it was a co-degree there and actually at the Hebrew University of Jerusalem. So I did that degree and then graduated. That was 2009, so middle of the economic recession, not a great time to get a job in the nonprofit world. So I had always been told I should go to law school. My grade 7 teacher was the first person to ever tell me that, and it's really always been pushed on me. My mom's actually a judge out in Ontario, so I'd kind of resisted law, even though I think I liked it and I had an aptitude for it. I just thought that because everyone else wanted me to do it, I wasn't going to do it. But I decided to kind of take the LSAT on a whim and just see how it went. And I ended up doing very well. I ended up teaching for Kaplan LSAT prep test. because I got in the 99.9th percentile. So taught with them for a year and then went to Osgoode Law. I was very torn between UBC and Osgoode. I actually had already paid a deposit on UBC Law when I last minute switched to Osgoode, but I definitely don't regret that decision. I think Osgoode Law is phenomenal. So I went there, and then I articled, well, sorry, step back. In part of the reason I chose Osgoode is because they have much more of a practical component than most law schools. So they have a ton of different clinic programs in third year you can do. There's a business law, family law, obviously crim, I think international relations as well. So I did the criminal intensive in my third year, which meant that I got to work with practitioners as opposed to being in law school. And through that, I got a lot of experience shadowing defense lawyers and shadowing Crown Counsel. I then articled for Crown Counsel in Toronto, and then moved out here to BC once I was done articling, transferred to become a BC lawyer. I then did some Crown work here, both in the Surrey Crown office and the New West Crown office, before kind of to get my sea legs, and then opened up my own defense practice right after that. So I've had my defense practice now for 4 years. I am a 6-year call. Yeah, I think that's pretty much everything.
Wow. You guys have so much experience, and such a varied experience. So I think everyone's going to get a real broad overview of different aspects to criminal defense law and different ways to enter into the legal sector as well. For anyone who's watching, you can ask your questions, just post them in the comments, and we'll try and filter them all in, or we'll do them at the end. I'm going to keep you muted for now, just so that if you have other people wandering around in the background, it doesn't interfere with everybody's sound quality. But please do ask your questions. Mitch and Leeanne are very happy to try and answer as many as they can for you. So we're going to get into some of the questions that we were sent ahead of time, so as part of your registration. So my first question for both of you is, why criminal defense? Why did you choose criminal defense rather than, Leeanne, you were doing things with children and things like that? So what made you switch across?
Well, for me, so as I said, I went to law school, not 100% certain I wanted to be a lawyer. And then my very first day of law school, my first criminal law class, that was it for me. I knew right away, I was like, I can't believe I didn't realize this was a profession. It just kind of hooked me, which I think it does a lot of people, hook, line, and sinker. So I immediately started focusing on criminal defense or criminal law, initially focusing on the prosecution side of things, and then became defense, I think, because of the job flexibility. So with Crown Counsel, you are obviously a government employee. So you are working mandated government hours, set vacation, set salary, all those things. And I've always been a bit of an independent person. I tend to work better when I have flexibility and can make my own work. So defense really just suited my personality better. You can end up making a lot more money. And you have a lot more freedom with the kind of work you do. So I can choose to take on a case. I can choose not to take on a case. So I just really like the flexibility of defense. And then it kind of actually does tie in a bit to what I was doing before in the nonprofit sector, because it allows me to take on very different types of clients, because I will have sort of the white collar crime, high paying client that will kind of cover the bills. And then I will have the sad individual on the downtown east side who maybe is struggling with mental health and drug addiction, committing petty crime, and I really get to help them. We have a specialized court here called the Downtown Community Court that I do a bit of work at, and basically it's an integrative team where we've got a forensic psychologist on site, we've got nurses, drug treatment, things like that, and so I get a lot of satisfaction out of working with those clients so that I can kind of give back and help. So
Fantastic. And Mitch, what about you?
Yeah, I also echo what Leeanne said about the Downtown Community Court and helping those types of people. I think that I came from a helping type of background when I was studying psychology. And so I always had this idea that I wanted to do something where I could help others. And I really thrive when I'm kind of up and out and about and talking to other people, and think that I'm a very social person, and it can cultivate good relationships.
That definitely is.
And so I wanted to do something where I could kind of take a lot of that. And then I realized as I was getting into law school that the philosophy really actually helped in terms of being able to logically piece together arguments and think of something that would benefit one side of the argument and the other. So I actually am really happy to be doing defense work, but I'm still young in my career. I could totally see myself wanting to try to do a little bit of ad hoc work, maybe for the Crown, to kind of see what that would be like. And I think that criminal defense law is really exciting because it's very real and it's very tangible for people, and so you can seriously feel like you are making a difference as opposed to just maybe kind of more mundane. Well, I say that, but I'm sure it's not for others. But you know, I'd never anticipated that I would want to do something where I'm just kind of sitting behind a desk all day. So I really like that I'm in my car and I'm hustling and I'm in two different courthouses at once. You know, I might start my morning in Surrey and then finish off in Port Coquitlam, and that's very exciting to me as well. But more than anything, I wanted to do something where I felt like I could make a difference, and I thought that my skill sets really kind of pushed me in that direction. And then when I was at the University of Sussex, we also had a lot of different hands-on type of practical stuff. I did mooting, I did the criminal advocacy competition and client interviewing and negotiating. And so any kind of skill set that I could try to learn and get some practical experience, I wanted to do that because I didn't really have any legal hands-on experience going into law school. And I just found that the mooting and the criminal defense advocacy program was really, really exciting. It's kind of, to me, I always thought that if you were going to be a lawyer, then for me, in my mind, it meant you were going to be there in person. You were going to be talking to the judge, kind of like you used to see on TV and stuff like that. And I wound up doing quite well at the defense advocacy competition, and it just kind of led me down that stream. And I thought that it was a lot of fun and exciting, so I stuck with it. And for now, it seems to have worked.
Thank you. That kind of leads me to my next question, really, Mitch, is so that experience that you got whilst you were at the University of Sussex, has that really helped you now in building your career and finding your articling position and then later on your associate position?
I think so, to a certain extent. I mean, I don't know if it's realistic to think that those things have a direct correlation to finding the job, but I think that it certainly makes you more marketable, and it gives you a lot more stuff to talk about. And importantly, it gives you some practical understanding of what work is going to be like. And for example, in the advocacy competition, we did mock bail hearings. The whole thing was designed to be a full trial. And if you kind of got far enough in the competition, then you got to the point where you can do a whole trial. So actually knowing what that would look like in pseudo practice was definitely a talking point when I got into my interview for the criminal articling position, because they want to know what type of experience you have and how serious you are about criminal law, and to be able to say that, yes, I've done mooting, I've done this and that. I think that those were certainly talking points, and the reality is that as an internationally trained lawyer, I think that firms are starting to become more understanding about what that means and the benefits of having good life experience and taking on the pressures of doing things like that. But they're also not exactly completely aware of what those differences are. So you get the option to kind of tell them about that and then relate it to things that already exist in the Canadian law school system, like mooting and practical advocacy stuff that Leeanne spoke about as well. So I think that it's certainly something that you need to do. I actually, as well, I almost forgot, but I was the president of the Canadian Law Society while I was at Sussex University. So we had a group that we all kind of met, and we did little events. We went to Dieppe to partake in the Remembrance Day competition. We went to Canada House in London, and we're a part of a networking event with other universities. So I would say that anything that you can do to enhance your CV when you come back is going to be beneficial to ultimately being more attractive in terms of getting your name picked out of the pile. And then once you actually get the interview, I think it's kind of up to you how you highlight those skills, but they are necessary, in my opinion, to stand out.
Fantastic. And Leeanne, so you originally were called in Ontario, then you transferred over to BC. How does that work? Like, what are the steps involved in it? Is it as simple as just signing a piece of paper?
Not quite that simple, but yes, it is relatively simple. Transferring within the country is not that complicated except for Quebec, and that's because they obviously also have the French Civil Code. So it is quite different to transfer there, but otherwise the other provinces do have an agreement for transfer, where essentially you read this lengthy document and say, I promise to learn any of the differences between the provincial laws, and you sign it, and then you pay, I don't remember how much, but an absurd amount of money to the Law Society, and that's it. So it is actually quite easy to transfer within provinces. So if you're considering different law schools within Canada, you don't necessarily need to worry about where you want to end up in terms of picking your law school, because there is a fair bit of transfer.
And did you find there was a lot of difference between the criminal code between Ontario and BC?
No, so that's what's nice. I have a friend who transferred out here as well, who does family law, and it's night and day. It's completely different. Whereas because the criminal code is a federal statute, in terms of what I do, from the legal perspective, like the actual law, there's no difference at all. There is some difference in terms of how we practice. Ontario has a somewhat different court model than we do here. There's just a different interaction between the defense and the crown system. So there was a bit of a learning curve there, but otherwise it was quite simple.
Okay. That's great. That's really handy to know that, there are ways that you can move across and you can move around the country and you're not stuck in one location, because, life happens, right? We change and we decide we want to be somewhere else. So it's nice to know that there is a process that you can move and you don't have to do the whole equivalent of the NCA process again.
There is. The one thing I would say, and this actually kind of echoes a bit of what Mitch was saying as well, is really focusing on experiences and opportunities in law school, because you're going to want those contacts. So that, Mitch was saying that's part of how he ended up finding out about the Myers articling job. Very similar, wherever you go to law school, just make sure that you are getting involved in the opportunities and building up your network, because you never know when you're going to need those people, and similarly they may need you. So you really want to work on building the connections, so that if you do want to transfer areas of law, maybe you start in one and you don't like it, or you do want to transfer provinces, you want to have people you can reach out to who can directly assist in that way.
Great. So my next question is criminal defense law like what we see on TV? I mean, I watch, How to Get Away with Murder. I don't think that's really that realistic day to day for most lawyers, I would assume. I guess it's kind of like Suits for corporate lawyers. We don't really all walk around like Harvey Specter. But can you guys give us, what's a typical day, a typical week? I know right now it maybe isn't a good idea to use right now in the current situation we're in for anybody. But, pre-COVID, what was your typical week, typical day like? Either of you.
Mitch, you want to tackle this one, or you want me to go first?
I'll give it a shot, because I'm sure with your experience, you'll add to it. I think that it's sometimes maybe you feel like you're on TV, but I'm sure that it's not actually really like it. I didn't actually watch How to Get Away with Murder, but I did recently watch all of Suits, and there is something kind of fanciful about wanting to think that you can act that way. But in reality, you would never, for those of you who have seen Suits, I mean, you would never talk to opposing counsel that way, or I mean, as you can see, he clearly takes a lot of liberties with a lot of ethical boundaries and stuff like that. And so above all, you always have to remember that you're an ambassador to the court, and your reputation is paramount about everything. If people feel like they can't work with you easily, or if they can't trust you, then you're as good as done. And I think Leeanne would agree with that. But there's definitely moments. I remember my first trial, I kind of got up and I was about to do my cross-examination, and I kind of just had to take a second to kind of look around and take it all in, because you spend all this time freaking out to get ready and preparing. And there is definitely something very fun and rewarding in the middle of it, to take a moment and say, wow, this is really exciting and this is really cool. I mean, lots of people only watch it on TV and they don't have the opportunity to actually do it in practice. So some aspects I'm sure are kind of similar, but a regular day for me will be to go to my office and get my day started. depending on what's going on, of course, you will have prepared a week or the night before to get all of your notes and everything in order. And then regardless of whether or not I'm too busy, I try to schedule my weeks so that I always have something to go to the courthouse to do. And I think that it's good to show your face and build your relationships with people and your contacts. And then court starts at 9 or 9:30, depending on which court you're in. And depending on your level of seniority or who is calling the court list that day, sometimes you have to wait around a little bit more, but you want to try to be as efficient with your time as possible. And ideally, if I can get a sentencing or two and a bail hearing done in the morning, then for me, that's a very good day. And then I like to try to get back to the office in the afternoon so that I can get ready for the next day or whatever it is that's on the go. So fairly standard in that regard, but maybe Leeanne could tell us a bit more about what happens during those sentencings and stuff like that.
Sure. So I would say, kind of picking up where Mitch left off, I as well try to start my morning going into the office. I saw a question, so I'm sure we'll get to it, but it popped up, so it's in my mind, about workload. I think Mitch would agree we do work much more than the traditional 9 to 5. The nice thing, again, is you have flexibility. So let's say you want to take a noon yoga class or something, you can totally do that. You have flexibility, but we definitely work long hours. So I'll usually try and be in the office by 7:30 or 8 so I can get stuff done and then begin my day in the various courthouses. What I think I like, and this is why it's kind of hard to answer the question, but what I like about criminal defense is there is no typical day. Every single day is going to be so different, because sometimes you're doing trials. So sometimes you're going to a courthouse and you're in that one courtroom doing a trial all day. You're super focused. Other days you've got you've heard Mitch mention sentencings and bail hearings. Those are kind of bread and butter for a criminal defense lawyer. So you might have 4 bail hearings to go do in Surrey in the morning and then a sentencing in the afternoon in Port Coquitlam. So you end up moving around a lot. And then you also may think you have a schedule. You may be thinking, okay, I'm going to Surrey for these bail hearings and POCA for the sentencing. And then you may have a client arrested overnight and then be off in New West for that. So there's a lot of kind of on the fly stuff. And even with trials, you may think, okay, it's a full day today. I'm in the middle of a 4-day trial. We've got 3 witnesses today. And you show up and the Crown says the witness recanted, we're dropping the charge. And suddenly you've got a free day. So there is so much change and diversity in each day. And I think that is what draws pretty much every criminal defense lawyer I've talked to. That's one thing that they really thrive on, is the fact that it isn't any sort of repetitive nature to your day.
Agreed.
So I'm going to skip ahead with my pre-sent questions, just because I think this one kind of zones in with what you guys have just been talking about. But how do you go about finding your clients in the first place to then be able to schedule what your caseload is going to look like?
So I think this is an interesting one, because I think Mitch and I will have very different answers for you, which I think will be helpful because we are different years of call. So for me, a big part of how I started getting clients was through referrals from colleagues. So because I had started working a little bit in the Crown office in Surrey and New Westminster, I'd made a really good relationship with a lot of defense lawyers through that work. And so when I said I was starting out on my own, a lot of them said, great, like we can give you some of our smaller clients. Like if they have a theft coming in the door and they're in the middle of a murder trial, they're not going to be able to do that. They're not going to be able to do justice for that client. So they would tell the client, I have someone else who I think could, better represent you right now. And they would send that client to me. So that's kind of how I built it initially, was definitely other lawyers' referrals. Then it really is the kind of career that snowballs. So, your first year, you can expect to not be that busy. Well, if you're not at a firm, if you're on your own, you can expect that things are going to be slower and you're not going to be making that much money. But it does a complete one of these, because it really grows so exponentially based on the fact that once you have 5 clients, assuming you do well and those clients like you, they're then going to tell their friends, they're going to tell their friends, and it just booms that way. So Mitch has a really nice website. I've been on it looking for one of his colleagues' information the other day, but I don't even have a website. And that's because I just don't need one. And that's not part of my practice, because my stuff is pretty much all word of mouth. I don't need someone Googling me to try to find out information about me. That's not personally how I like to practice. I go off word of mouth from my clients. My clients trust me. And so often you'll get clients by someone who may be in one of the pretrial centers awaiting their bail hearing. They might be in a cell and their cellmate's like, oh, I need a lawyer. I don't have anyone good. And then my client will say, oh, here's my lawyer. She's great. And I'll get that new client that way. So for me, it's I would say at this point, predominantly just word of mouth between my clients, and then repeat business, which kind of sad state of affairs, but there is a lot of repeat business. And so you kind of don't need too big of a caseload all the time if you have a couple that are constantly coming up and you can kind of rely on that. So.
Okay.
And for me, I think one of the benefits and one of the real attractive qualities of leaving Myers and Company and going to start with Ferguson Allingham was that at the time, because it was such a new firm, I was the only junior associate, which obviously had a lot of appeal because anytime, as Leeanne described, if they were busy and just didn't want to do something, or sometimes to take, an hour and a half worth of driving just to go for a 15, 20-minute bail hearing out in Surrey wasn't necessarily how the senior partners wanted to be spending their time. But for me, as a young, hungry lawyer, I would be all over that all the time. So I would get a lot of work to get started from those guys as they were kind of trying to lean out some of their legal aid practice. I would pick that up. I would say at the moment, and then especially in the first year to get started, 90%, maybe even more, was legal aid work. And I took the view that, I was trying to let people know that I would want to do any type of work. There was no file that was going to be beneath me or above me, and I knew I had support at the firm to do all sorts of different things. And you'd be surprised how much work you can even get just from going and talking to the people who are responsible for helping clients get connected with legal aid. So I went to all the different courthouses and introduced myself and left my my card with them. And same with the MPA Society that helps people with mental health, and the First Nations advocates that help people who are First Nations. So there's all these different resources in the court that if you can tap into, then they'll say, okay, well, this person's looking for help. Hey, do you want to help them? And then I think what Leeanne said is really most important, that you want to hope that you can do good work and be readily available for people, and really just be compassionate and be there to help them. Because although we often want to feel like we're doing everything that we can to completely solve their problems, I mean, these are people with a lot of complex issues and backgrounds. And so the reality is, for many of them, they are going to need help again. And that's when you want them to feel like they can trust you and come back to you. But you'll never know who a client is going to wind up being. So I take the view that it's always good to just be at the courthouse, like I said, because it's difficult to necessarily rely on only people finding you, like Leeanne said, when you're just getting started. And sometimes I've had somebody just pass me in the hall and be like, hey man, do you know where courtroom 107 is or whatever? And I'll say, oh yeah, for sure, it's right there. And then they'll just be like, oh, are you a lawyer? And you're like, yeah, do you need help? Like, is everything okay? And sometimes business comes in the from the weirdest spots, or somebody will call me and say, hey, you helped my friend with this and he gave me your number. So that type of work, I think, is really gratifying, because it means that you're making good impressions on people. So who knows how much work actually comes and funnels in from the website. I don't really have much to do with it.
So that kind of leads me to a question. You guys were talking about how you can basically choose your own schedule to some degree, because you have that flexibility of taking clients on or not taking clients on. Do you get those middle of the night phone calls? So-and-so's in jail and they need you to come down right now. Does that actually happen?
Yes, we do get them, especially as a student. We used to, at Myers and Company, it's quite a large firm, and they do a lot of legal aid work. And I think at the time when I was there, there was 11 or 12 lawyers there. So we had what was called the bat phone. And after office hours, they had a call center, and anybody who needed to speak to a lawyer or got arrested got first kind of funneled through the students if they weren't available, if the main lawyer wasn't available. So as a student, there was tons of calls that happened. I think that it's quite rare. I could say that I've never actually woken up in the middle of the night and went down to the police station, because at that point, there's not really very much that you can do, but you do have a responsibility to take those calls for two reasons. One, you need to know that your client's arrested so you can go to the courthouse and actually help them effectively the next day. And two, you need to let your client know what they can expect. They have their right to silence, of course, so they don't have to speak to the police. And often the police in those first moments are going to be trying to get statements from your client, and those statements are almost always going to hurt your client's case. So you need to tell them that they're under no obligation to speak to the police, and inform them, usually if it's that late at night, that there's nothing that we can really do right now, but hang tight and I'm going to be there for you in the morning to help you. So a lot of it is actually more about client management and making sure that their rights are intact than actually flying down in your bat cape and getting them out right there on the spot. Although I actually have had 1 or 2 times where I've spoken to the police, and depending on the severity of the crime or how bad of a criminal record that person has, sometimes you can speak to the police and try to influence them to release them on what's called a promise to appear or some form of paperwork, as opposed to having them needing to be held in court to go before a judge. So it is very important that you pick up those calls, but I never have gone in person to the police station. I don't know if you have, Leeanne.
I have only once, but yeah, I'll echo what Mitch said. It's pretty heavy in that regard when you're a student, and when you're a junior starting out, you will get pretty consistent, a couple calls a night. But that as your practice sort of, I guess matures might be the word, you will have less of that. So I think I've had 1 overnight call in the last 2 weeks. And that's just based on the kind of work you're doing. They're not, it's just not going to be as busy in that regard. And then, yeah, like Mitch said, when you do get those calls, though, it is really important. So you do need to be prepared that if you're going into criminal defense, you're going to have some interrupted sleep nights, because, you know, you need to wake up at 2 a.m. and you need to, within an instant, get your game face on, because, you know, while this is another, you've done this 1,000 times, this may be the first time this person has heard this speech about needing to keep their mouth shut, right to silence, about how there could be a mole placed in the cell to get statements out of them. So you really need to walk them through the situation they're facing and kind of try to calm them down a lot of the time, and explain that it's the middle of the night, so court won't start till the morning, but you'll be there in the morning, and kind of calm them down. But like Mitch said, you almost never go down to the police station, because it's simply to explain to them that court will be in the morning. The exception for that is when they're charged with murder. When you're charged with murder, you do get an in-person visit, and that's because they're usually going to take quite a lengthy statement from you, and put you under a lot of grilling. So I have had to go down once in the middle of the night for that purpose, and I spent about 2.5 hours, I would say, in the middle of the night preparing this client to withstand very intense grilling by the police. And they do let you have that in person for that purpose, but that's pretty much the only time you'll have to go in the middle of the night.
Yeah, and if I can add that, it's a funny kind of love-hate relationship with those calls, because as a student, you definitely don't necessarily want them because you're stressed enough as it is. But when you're getting started within the first year, you don't want to wake up, but at the same time, I almost don't mind getting it, because I know that I have work to do the next day. And that's a way that you can build your practice and ultimately make some cash. So you kind of want to get calls in the middle of the night, at
Totally.
least at the beginning.
Yeah, definitely. So you guys have mentioned legal aid. Now we know that legal aid is going through a lot of changes over the last, let's be generous, year, probably longer. How is that impacting both of you? I mean, I know, Leeanne, you have your own practice. Mitch, you work in a practice. Are you seeing impacts from the changes to legal aid pre-COVID?
I don't know what Mitch would say on this. I don't think there's been much. There has been talk of sort of grand scale revamping of the legal aid system for probably close to a decade, moving towards a sort of public defender model like they have in the US. But it seems like that's just talk, or at least it has been for quite some time. So the only real changes we've seen to the legal aid system has been changes to sort of the financial qualifications for people. And it hasn't made that much of a difference, I don't think, in the criminal perspective. I think it has, in the family bar, impacted them more significantly. But for criminal, it hasn't made that much of a change. And then the only other change is we are finally getting paid more, which is obviously making a difference on our bank accounts, which is nice. So.
Yeah, and I should add, if I did make this clear, that although I work with a firm, we all at the firm operate as sole practitioners. So while there is an overhead scheme so that I could be a part of it and they help give me work and everything, I am largely responsible for making sure that I could come up with those numbers and everything at the end of the month. So that said, the increase that we got not long ago from legal aid was certainly a welcome one for me. I think that I certainly benefited by coming in at the right time and kind of riding the coattails of other lawyers like Leeanne, who have been doing this for a lot longer than me. And, you know, within my first year, I got a raise, so I must be doing something right.
That's always nice. So there's also obviously COVID right now, and this is being asked quite a bit in the chat. How is COVID and the global pandemic right now affecting both of you and the criminal defense bar in general?
There's been a number of changes for the first month or maybe a little bit more. They essentially went into like a lockdown of the courts. And unless you had something that was deemed to be urgent by a judge or had someone who was in custody that was nearing the end of their sentence and of course needed to be sentenced and get out, or a client who was newly arrested and needed to have their bail hearing, for your kind of everyday stuff that was out of the out of custody person, those matters were just automatically adjourned for 90 days. And we got an update this past week that they're doing a second round of 90-day adjournments for stuff that isn't urgent. So it's definitely had an effect on me as somebody who has a primary legal aid practice, and a lot of my clients had been out on bail, and we're trying to work towards resolving the matters or setting it down for trial. So everything right now is definitely slower, and I feel that not only my day-to-day and sort of kind of motivation to keep working and being busy, but also financially as well. I think my biggest concern right now is that I have some things that I can get done, but I'm not entirely sure how I'm supposed to kind of go about getting new business now, because I got a lot of business from being at the courthouse and working my relationships and going down to see lawyers. I actually remember one of the first times I met Leeanne. Leeanne was the duty counsel, and she was helping a lot of the people who don't necessarily have lawyers. That's the role of the duty counsel. It's a free lawyer, and we had met once or twice, and she was definitely really kind and instrumental in kind of making sure that I knew what was going on. And she said, oh, hey, like, why don't you go and speak to this person? They don't have a lawyer. And so that's why I like to be at the courthouse, because you never know what's going to happen by being there. And so without that opportunity, I'm definitely a little bit concerned about how I'm supposed to now replenish the clients that I've finished sentencing or working with at the moment.
Yeah, I echo that entirely. And as someone who's practiced, I still do a fair bit of legal aid. Don't get me wrong. I think legal aid, mostly because I think it's very important work, but I do have less of a legal aid practice than I used to. I have more of a private practice, but it's impacting the exact same way because private clients are not having court dates either. So there isn't that work. So the last day of operational court was March 18th. And then since then, we have been on this full lockdown. What we have moved towards, as Mitch was saying, is urgent things are still happening. And what urgent meant has kind of changed weekly as changes are rolling out. And we really are getting probably, what would you say, Mitch, like 4 to 5 emails a day?
Oh yeah, too many.
Like things are literally changing daily. And so what it is now, though, is the only thing that is considered urgent. There is one trial happening. That's it. I don't know if it's the entire province or at least the lower mainland, but there is one trial going ahead. It's a murder trial in New Westminster. Other than that, no trials are going ahead. So the only thing happening is bail hearings. And the way those are working is it's all completely over the phone. So things have just been very slow because not as many people are needing bail hearings, because there has been directives both to the police to give people promise to appears as opposed to holding them for bail if at all possible. And there has been directives to the Crown Counsel similarly to only run the bail hearings if necessary. Otherwise, giving them their police release with a court date is preferable. So we've seen a huge drop in numbers of bail hearings. And that has meant that I think anyone who was on the call at the beginning probably heard Mitch and I just chatting about what our days have looked like. Neither of us had any bail hearings today. And that's becoming the norm. Whereas I think prior to this, we would each be doing upwards of 5, 6 a day. So it's a big change. Certainly the biggest I've seen in my career. And it's impacting criminal lawyers, I think, very differently than most, because other lawyers, their jobs can still be happening. If you're not a courtroom-based lawyer, if you're normally working in an office, you can still be doing that work. My partner is a copyright and patent lawyer, and he is still working normal hours because that can still be done. So it is impacting criminal lawyers quite uniquely, or I should say criminal and family law as well, because the family law legal aid lawyers similarly can't be in court. So I think we're all just kind of playing catch up with where this is going to go and when this is going to end. And I think they're coming up with ways to try to open court as soon as possible and get us back doing things.
So do you think that the way they're dealing with bail right now will continue? Like, do you think it's going to change the practice and you're going to have the police doing more?
No, I think it will go back to normal as soon as possible, because there's just a lot of technical problems that are coming from it. It's not as great, I think, for the clients because they don't have that same face-to-face interactions. Like, I like to be able to sit down with my clients, look them in the eye, reassure them of what's happening. And then right now, normally a judge would read someone their bail conditions, and then they would sit before a justice of the peace, and a justice of the peace reads it through line by line by line, and they sign it. That's not happening right now. They're just being read it over the phone, and that's considered presumptive. Yeah. And I see there being a lot of challenges with that, especially with some of the higher needs individuals. So I think we're going to try to go back to normal as soon as possible. And that's my own opinion. I don't have any wording that's out there from the government on that, but I think we're going to go back to normal as soon as we can.
Fingers crossed.
Yeah.
Yeah. Let's keep like access to justice as open as possible for people like on that one. So one of the questions, I'm going to skip ahead, then I'm going to go back, is how do you guys manage the stress and the emotions of working in an area of law that can be, you know, quite intense? There's a lot of emotions. You're dealing with people's liberties and their lives. How do you guys manage that?
Well, it can be very heavy. I mean, there's nothing worse than kind of losing a trial in my recent experience, because you put so much of yourself into it, and it is sort of a very divisive thing. It does feel like you either win or you lose sometimes, but I think it's important to take a step back and remember that on your day-to-day, when you're dealing with these people, that it's your job to make sure that they've got access to justice and that you're doing your best to make sure that their rights are upheld. And importantly, I mean, you're not the one that put them in these situations. You're dealing with people who have complex problems, but they've got their own autonomy. And really, I think that I personally take satisfaction in knowing that I'm one of the few people and one of the few supports that they have that are actually trying to help them move away from some of these problems and can be there for them when they need me to. So it's difficult at times to not sort of take their problems as your own, but I think that you have to have a bit of a practical approach and remind yourself that you're not the ones that put them there, which is part of the nice thing about being defense, I would think, as opposed to being the Crown Counsel. So you are on a sort of a different side of the coin morally.
Yeah, I would echo that. I think you have to pretty constantly remind yourself that at the end of the day, you're doing your best and your job is to represent them, but this is not your case. And there is that, like Mitch said, horrible feeling when you lose. It is devastating. It feels like you lost, and you have to remind yourself that no, you didn't lose. This is not about you. It's about the client, and it's about the evidence. And so I think you do need to practice that distancing. The other thing I would say is really leaning on your colleagues, because depending on the case you're working, you know, if you're working something very dark, it does get overwhelming. And I was in a very complex trial last year that had a lot of really graphic evidence. And yeah, I would make sure at least twice a week, obviously spending time with your friends and your outside of the law friends, but at least twice a week, I would go and grab a drink or have dinner with my colleagues just to kind of commiserate about that, because they can really understand where you're coming from when you're like, hey, I've been looking at photos of XYZ all day and I feel nauseous. And it really helps to have them remind you that you're not alone in this, and to really help pull you out of that dark place.
Yeah, and I think it's really important to do it with colleagues who actually understand, because sometimes I've noticed that you become accustomed to the type of problems, and it's not to say that you downplay them, but sometimes like you'll be trying to explain a situation to someone else, and maybe it sounds like you're not necessarily being compassionate or anything, but they just don't get what your gripes are all about, because it's so much different than just saying like, oh, my boss gave me shit today because I didn't do X, Y, or Z. And a lot of those things that you do are things that you put on yourself. But I think that it's also important to not get too emotionally involved with the client or with the case or anything, because we have the difficult job sometimes of having to be very objective. And I was at a conference once, and a very experienced lawyer said that we are the bringers of reality. And I liked that, because sometimes if you go in and promise the moon and then you underachieve, you're going to have a client who's not really happy with you. And oftentimes we have to convince clients to be confronted with the evidence and make the difficult decisions to say, okay, you should plead guilty because you don't really have much of a triable issue here, even if that means that that person's going to spend the next 6 months or 6 years in jail. So
And
if you,
that's an art form that you get better at as you practice. It's something that you're not born naturally with. It's very uncomfortable to have these conversations with clients. And, you know, Mitch and I have both had to do that a lot. We've had cases where you look at the evidence and you're like, I am telling you as your counsel that your best situation right now is to take a plea deal, because they have a strong case. And that is an uncomfortable conversation. But your job, like Mitch is saying, your job is to not be that, you're not the client. And you have to have that distance to be able to look at it objectively, to give them a fair assessment of the case.
Yeah, definitely. I would be useless. If you guys came to me to talk about your day, I'd be like, that sounds great, guys. Like, I genuinely would be useless.
We also have a terribly dark sense of humor.
yeah. And actually, I wouldn't mind talking to you, because sometimes you want to just speak and not necessarily have anybody like speak back to you, because our clients do that a lot.
Sure, if you guys ever need someone to just sit there and be like, I am totally a person to do that for you. Okay, so for both of you, what was it like starting your own firm? Like, to like go away from almost that security blanket that it can sometimes feel like to be in private practice or to work for Crown Counsel, and to go on your own. What was that like? And how did you go about making that decision and then just jumping?
Yeah.
Sure. Well, I think, I mean, it's obviously going to be that terrifying moment where you first kind of rip the Band-Aid off. That's in any profession. If you're changing a career, jumping out on your own, it's terrifying, and you have to just rip that Band-Aid. But honestly, I think in criminal law, more than anything else, it's less scary because it's so common. So there are, I mean, maybe Mitch has better numbers on this, having worked for Myers, but I would say there's probably only a handful of practices for criminal law in Vancouver. It's very much a isolated profession, and similar to Mitch, who's in a firm but a sole practitioner. I'm not in a firm, I'm completely a sole practitioner, but I do an office share. So there's 6 of us lawyers all together to bounce ideas off each other, but we all run our own practices. And that's extremely common. So it's not as though you're going to say to someone, I'm thinking of opening my own practice, and another lawyer is going to be like, what are you thinking? It's almost expected. I think when you're articling, it tends to be assumed that you're going to go out on your own. And then if you're not, people are surprised. And they're like, oh, you're joining a firm. Interesting. Tell me more, because that is more rare. It's very common in crim to go out on your own. And so it's not that scary because there's a lot of guidance. And that's the one thing I will say is, like, I've never experienced with the criminal defense bar, is the collegiality and the community. People will bend over backwards to help you. The mentorship in this community is like none other. And people want to see young up and coming lawyers succeed. Especially, I've been very lucky as a woman in criminal law because there isn't that many. And so the senior women are so willing to address problems with you and problem solve and just really bring you up the ladder. And so that really helps when you're starting out. You have people, you can call up so many different senior lawyers and ask them tips. You have people referring you clients, and it really gives you a leg up.
Yeah, absolutely. I've definitely needed to call a bencher once or twice, and like without hesitation, everybody takes that role in the mentorship really, really seriously. I would say one thing to be prepared for as a start is that it can be stressful. I often joke around with people that I feel like I'm always stressed because I'm either stressed because I have like too much work and I need to figure out how to prioritize my time, or I'm stressed because I don't have enough work and I feel like at the beginning of the month I'm like looking at my empty schedule and I'm thinking, how the hell am I going to pay for my rent this month? So it's not like working at a corporate law firm where that I understand, where you just get a base salary and you could count on having the same amount of money deposited into your bank account every other week or however it is that it works. You have to go out and often find your own work, and then like Leanne said, you only really get paid when that work comes to fruition and you go in front of the judge and do a sentencing. So sometimes it's necessary for your client to go and get some counseling, and so all of a sudden that's 2 months down the road before you can actually do the sentencing and get paid for that work that you're doing. So it's always important to have in a legal aid practice a fair amount of clients on the go. When I first started, I had about like 15 or 20 clients, and I kind of did all of the work for all of them. And then one day I woke up and I realized, oh, I don't actually have any clients anymore. So I needed to kind of start again. So it's always good to think about trying to get a client as you get rid of a client. And that way you have a bit of steady income. But it can certainly be stressful. And I feel very fortunate that for me, it was the right move to join the firm at the time that I did, because there was a clear opportunity for me to have a couple of files gifted to me so that I could get started and have something to do.
And yeah, I guess you guys are both business owners as well. So you both get to have that entrepreneurial side of you as you manage your own business, and you have a bit more control of it, rather than maybe if you're in a traditional private practice setting where it's all potentially done by other people. You get to do all of that. So it's more akin to, if you're in the UK and you're used to it, it's more of like a chambers sort of model, whereby, at least for you, Leanne, where you're in a shared space, and you just split the cost of those common areas.
We have a shared legal assistant. We have shared rent, printer, fax, all that stuff.
Yeah, and it's amazing too, because I think one of the things that we both like about the work that we do is that it's kind of on the fly and you have to be very resilient. And I went to law school and I articled, but none of those things prepared me to be a business owner. So, you have to have a group of people, whether you work with them or just throughout the community, that you can ask questions to, because you have to be very careful with money that you get from clients and how it goes into trust and how that then interacts with your general account. And I don't know about Leanne, but I'm always worried that I'm going to put something in the wrong place and they're going to take away my license.
It's a constant nightmare for criminal lawyers. Like, oh my God, did I accidentally deposit into the wrong account? It's a constant fear.
So having good support like that, we have a bookkeeper at our firm, which is like a huge help to be able to do that. But in terms of like actually like managing your own practice, I think the most important thing is to just do good work and hope that other people see that, and that the more senior lawyers can trust you to do work.
And just jumping off that before we move on, that reminds me, I meant to bring that up earlier. Another way you can get work when you're starting out is as a junior. So it's less common now because the legal aid system doesn't seem to authorize as many junior hours. But what they do is that on more serious, more complex cases, things like murders, significant ag assault cases, anything that's going to be a lengthier case, they will often or sometimes give senior lawyers a certain allocation of junior hours. And then that senior lawyer then gets to go hire whomever they want to be their junior on the case. So that's how I started getting into the more serious work. 3 years ago now, 2.5, 3 years ago, I juniored my first murder trial. And again, it was just a contact thing. It was a senior lawyer he's phenomenal, and it was a privilege to work for him, but he had seen some of my work. I think he was in court one day when I had done something. And so he just called me up and said, I've got this authorization from legal aid. Do you want to come on as my junior? And I about hit the floor. I was so excited. And so you do have that opportunity to get clients and money that way, even though it's not actually your own client. You're able to get paid work and incredible learning opportunities through that.
Yeah, I think the learning experience in those situations, I haven't been fortunate to do that yet, but you get so consumed with having to do your own work as a junior lawyer and trying to figure out where your next paycheck is coming from, that you maybe lose some of the opportunity or the readiness to want to go and actually junior somebody. And even I think I haven't done it, like I said, but even if there was something that was interesting to you and you have to maybe sacrifice a couple days of pay, you'll be happy that you did just because of the learning experience that you'll get, because you're on your own. I mean, at the end of the day, it's you standing before the judge trying not to put your foot in your mouth. So you have to make sure that you can tap into whatever resources that you can.
That's a brilliant segue to my next question. So, Leeanne, I know you have an articling student now.
I do, yes.
Is this your first articling student?
It is, yeah. So the way the rules work, the Law Society allows you to be considered to get an articling student after, I think, I'm 99% sure, being a 5-year call. So I was only eligible this past year. And most people don't take an articling student right away. I think a lot of people, maybe in the 8-9 year range, get an articling student. But it's a completely unique decision based on your practice, your income, because you are paying an entire salary for a person. And I'm actually doing something interesting where one of the women who I share an office with, her and I are sharing this articling student. So we're splitting her salary, we're splitting the work. And that's kind of what made me feel like I was in a position to take it, because I've got the experience and I've got the interesting work for a student, but I thought, do I have enough? Like, do I have enough to fully give her something to do 9 to 5 every day and the hit on my own income? So being able to share it has worked so well. We kind of get to make sure she gets a really varied practice that way. And yeah, we split her salary. And she was a foreign educated student. She studied in Australia and then came here and passed her exams, I think about 3 months before we hired her.
So what were you and your colleague looking for when you were hiring an articling student? Just this is not general for everybody, but what specifically was it attractive for you guys? What were you looking for?
We wanted someone, we did want a female, if at all. I mean, obviously we would have hired a male lawyer if we found a good one, but we thought it would be interesting to give another female in criminal defense that leg up, and that because we've been given so many privileges because of that, and we wanted to help another female out, because there is some unique challenges for any women who are on the call in terms of going into jails and dealing with male clients. There's just unique challenges. So we were hoping that we could find a young female eager for crim. I think the number one most important thing for us was that it was someone who was passionate about crim, and not someone who was just like, I'm looking for articles, like they'll do whatever. We really wanted someone who knew they wanted crim. And then we wanted someone who had experience in a sort of fast-paced career. So it didn't matter to us if it was in law related or if it was just something where they're used to being on their feet and being confident. And our articling student throughout law school worked as a bartender. And we thought that was perfect, because if you're able to be sort of confronted with people that are usually very demanding of your time, demanding of your attention, you're multitasking, you're doing those things. If you can do that, those skills directly translate into criminal law. So that was sort of the background we were looking for. We obviously wanted to make sure she had good grades in crim. Didn't care as much about the other grades, just that she had passed, but wanted to make sure she had a good handle on crim. I think those were kind of the main things.
Okay, and so one of the questions that we've got, which I think you kind of touched on, but was why you chose to have an articling student rather than hire an associate. And I assume that's more because an associate would be starting their own practice.
Exactly. So yeah, I'm just not at the level where I need an associate. I think the colleagues that are friends of mine as well that Mitch joined, they are more senior, so they're in a position where their practice is booming enough that they can have an entire full-time associate. I'm definitely not at that level yet, and I'm not sure if I would ever want to have an associate or if I just like having an articling student. I really enjoy that mentorship role. I've always liked being a mentor, so the ability to kind of teach someone and to watch how excited she is about things, it almost, especially as you're kind of getting into a mid-level lawyer where, you know, you're either dealing with the really challenging stuff that's new, or you're dealing with the stuff you've been dealing with for 6 years and you're kind of over it. It's been nice to be reminded of how exciting that can be. So, you know, I can go in now and I can do a bail hearing on the spot, no problem. And that's just everyday routine for me. And so when I got to give her her first bail hearing to do on her own, just to see how excited she was and how eager and how prepared, it motivated me as well. Like there's a real mutually beneficial relationship between an articling student and a principal, because it does remind me why I love what I do, and it reminds me I don't know, it just reminds you to pay attention to the little things.
It's great. Yeah. I get to mentor a lot, obviously. I get to be here and help an awful lot of people. And it's definitely a mutual benefit for both parties, and definitely reinforces for me why I'm doing what I'm doing, and the type of law that I practice is interesting to me for sure. Do you guys mind if I open up to questions from the floor? I know they've been coming in. There's lots and lots of questions in there. Hopefully on the chat we've tackled a lot of them. But if anybody has a question, if you want to raise your hand, I will unmute you, and then you guys can ask your questions directly, by all means.
Please do, don't be shy.
Yeah.
We won't bite.
Joa, do you have a question? Did I answer all of your questions?
I believe I wrote down all my questions in the chat page. In fact, most of the questions are from me. So almost all of them have been answered. Yes. Thank you so much, guys, for answering.
You're welcome.
You're welcome. You had some great questions.
Thank you.
So one of the questions we asked actually was more about like how you actually do a case. And so Yonique, I'm going to ask your question, was how do you approach preparing for a case? Like, do the case facts immediately jump back to your memory as you sit there and interview a client, or do you find you have to do like intense research based on what the actual facts are and the crime is on any given day? And then how would you then, once you've thought about it, what would be your next like steps? Is there like a sort of a process you guys go through?
I think there's a couple models I'd say that generally get followed. In terms of whether you kind of need to remember everything, you don't. So 99% of the cases you get are going to be, you know, a handful of charges that you know automatically. So theft, assault, sexual assault, I don't know, things like that. You know what, you've done it enough that you know what makes up that charge, what the actual things that the Crown needs to prove are. So unless you're getting something crazy unusual like alarming Her Majesty or something where you would need to look it up, you already know the main things Crown needs to prove. So in every case, they need to prove date, time, jurisdiction, identity, and then the criminal code will set out sort of the other things they need to prove for the charge. So for a theft, it needs to be, someone needs to be taking it without color of right, and they need to be obviously therefore taking it from the person. So you're looking to see, can they prove that? Or like assault, you need to be looking for, did they apply intentional force? So what you're doing when you're reading a case is just kind of looking at, in the back of your mind, what does the Crown need to prove? What is the evidence they think they have to prove it? And then when you're talking to your client, you're filling in blanks to say, oh, okay, well, they're saying they can prove the assault because they've got the individual saying he hit him and they've got an eyewitness. And then maybe your client says, well, I have an eyewitness who was sitting right here who will say I never touched him. So that's the kind of stuff you're doing. And you're basically going through your package of evidence, which is called disclosure. So you're going through your disclosure, you're looking at all the evidence, you're compiling it. And then eventually, if it's going to trial, you create a trial binder where you're breaking everything down by witness, kind of figuring out what their evidence is, what they're saying happened, whether that's you've got a transcript or you're looking at maybe a video statement. You compile that all, and then you kind of figure out what your cross-exam is going to be and what your theory of the case is. So you always want to have an overarching theory of the case, and then you want to have your smaller, well, how am I going to attack that? How am I going to prove it? So, for example, on an assault, your theory of the case could be identity. It wasn't your client. This guy did get assaulted, but it was by someone else. And so the way you are going to be cross-examining these people is going to be very different, because you're going to not be contesting that they got punched. You're going to be agreeing they got punched, but you're going to be focusing on why they think it was your client and the things you can show to prove that they couldn't be certain. Versus the assault, maybe it's not identity, but maybe you're saying it was self-defense. So then it's going to be a totally different style cross-examination depending on your defense.
And there's also the idea that if you are at trial, you don't need to prove that your client didn't do something, but that the Crown has to prove that they did beyond a reasonable doubt. And there's, of course, lots of case law about what all of that means, but don't get the lots, too much, but don't get the idea that all of this happens like super quickly either. You know, it's very common for disclosure to take time, and you'll read through the disclosure package and you know, they might say, oh, like so and so saw this, and then you need to go to the Crown and say, oh, well, it mentions this statement that I don't have, or there was a previous police report, can I please see that, you know? So sometimes that takes a little bit of time as well, and then, you know, you'll confront your client with that evidence. For example, I got off the phone with a client the other day, and he was charged with uttering threats to cause bodily harm or death. And the statement from the guy said that, oh, well, my client threatened to stab me. And my client said, well, no, actually I didn't. I just threatened to beat him up. And I kind of said, okay, well, you know, that's a bit of a problem, because even, you know, he was all like, no, I didn't threaten to stab him. I would never do that. But I did say that I would beat him up. And so you can't necessarily go through an entire trial and then have your client get up in front of the judge and say, no, I didn't threaten to stab him. I only wanted to beat him up, because that constitutes the charge that makes out the requisite elements for uttering threats to cause bodily harm. And one thing that you have to always be aware about, I make it my practice to try to canvass an early resolution and just have that as an option to give to the client, because your client will get benefit for wanting to take responsibility and potentially plead guilty to something at an early stage, because then it saves a lot of time and resources of the court, and your client will actually well, they will get a lesser sentence if you decide to do that than go to trial, get convicted, and then have to go to sentencing. So sometimes that is always an option, of course, and I'll want to talk to the Crown and see if there is a plea bargain or something that I can get, so that they really know what all of their options are. Option one, you can plead guilty. Option two, you take it to trial. This is what you would get before. This is what you might get afterwards. And I think that that's a useful exercise as well.
And just jumping off what Mitch just said on that point, because I think that it can be a bit misleading, because people think, oh, I'm going to be a criminal lawyer and I'm going to be doing all these trials. Trials make up a very small part of what we do. I don't have the exact stats anymore, but the last time I checked, which is probably only a year ago, only 10% of the cases in this province go to trial. And there is a 4% conviction rate. So again, if you look at it that way, 10% of your cases are actually going to trial. So it is a very heavy volume guilty plea and sentencing practice, just because, again, a lot of times the person is guilty and they will tell you that, and you look at the case and say, yeah, looks like the Crown can prove that. And then instead of going a trial on a Hail Mary that you might find something to win, if they're pleading guilty, they're going to be getting, it's called a mitigating factor. A guilty plea is called a mitigating factor. And so that will help them get a lesser sentence. So most of the time, where they're guilty and where the Crown will prove it, they're going to say, of course, I don't want to go to trial. I want to plead guilty. I want you to work out a good deal for me. So a lot more of our job is working out deals.
And the judges are pretty receptive, especially in Vancouver, I think, because they are really entrenched with the downtown east side, which is a large portion of the population that winds up before a judge. So I know, I only really know this Vancouver, Surrey, greater GTA area, but I know that you see like somebody coming in from Edmonton, you know, I don't think it's uncommon to have like a First Nations person from Edmonton that was caught with some drugs or something, and they get like huge jail sentences. And then you look at that and you're like, okay, here that would have been like a slap on the wrist, and like they let them go. So I think we're fortunate here to have a judiciary that is somewhat in touch. Somewhat, I say that loosely, but you know, you can get very good results, and the Crown is super reasonable, and it is very collegial and pleasant to deal with them too.
I think, Jawad, do you have a question?
Yes, I actually had two questions. The first question relates to how easy it is to work with the prosecution here. I mean, is it easy to work with them? Are they over enthusiastic about their work, or have you had experiences where you've not been able to work out a deal because the prosecution was not very easy to work with? That was my first question. And the second question would be regarding practicing white-collar crime. I know from my personal experience that white-collar crime is, although it is under criminal law, but it offers quite a different sort of an outlook into like it has a different, the life of a white-collar criminal lawyer is a little different, can look a little different. Is that the same case here? Are there nighttime calls for white collar criminal lawyers? Yeah, if you can talk a bit about that.
I think Mitch and I would both agree. I'm trying to be relatively brief, noting the time. It's great to work with the prosecution here. The Crown's office is lovely. Obviously, you're going to have the odd, personality clash, I will to say politely, the odd person you have a hard time with. But for the most part, the bar here is known. Like in other provinces, it's known as being incredible out here. People are so reasonable. It really does feel like everybody, of course, you want to get an acquittal, your client, they want to get a conviction, whatever, but at the end of the day, you're working towards the same goal. So they're great to work with. In terms of the white collar crime, I would say, yes, it is very different. I've only done one white collar crime case myself. But what I would say is important is, and I stand to be corrected if Mitch has a different perspective, but as far as I know, I don't think you could run just a white collar crime practice out here. There just isn't the volume of work. So I think if you want to do crim, you can definitely, try and specialize in white collar and, maybe make that as much of your practice as you can. But I don't think there's enough work that you could have an entire business on that.
Yeah, I don't think I've had a case where I would classify it as quote unquote purely white collar. I've had to deal with some fraud stuff where people definitely think they're trickier than they are, and sometimes those people are tough to communicate with. But I think to answer both questions, it really boils down to communication and interpersonal skills, which is what I personally really like about this type of work. And sometimes you can get to a point in your negotiations with the Crown where you're just not seeing eye to eye, and ultimately that's why we have judges, and then you say your piece and they say their piece, and you will let the judge decide. So you don't always have to sort everything out with the Crown, but they're super reasonable to deal with, and often socially, there's banquets and other events through the Law Society or any derivative of it, and we're out and we're interacting in social settings as well. So I think that you always want to take the approach that you get more flies with honey than vinegar, and you should always be nice to everybody, because ultimately, unfortunately, you're asking them to give you what you want, and they sometimes hold the cards. But if you can't get them,
and the crazy part is, like, these people could become your boss in that they could become the judges, right? Like the amount of Crowns and defense lawyers get appointed to be judges. So if you make an enemy with someone and suddenly they're the judge 3 years down the road, that's a terrible situation for you to be in.
Yeah, so it's always good to just be nice to people.
So final question. Then we're going to wrap it up and give these guys some of their evening back. Zakir, do you want to go next?
Hi, my question is to Leeanne. You told you took on an article student who was an ITL.
Yeah.
And I just wanted to ask you whether you had more candidates who were locally trained, locally educated, and if so, what made the ITL stand out over the locally trained candidates you had?
To be honest, it didn't even really matter to me. Like I think the final sort of like actual in-person interviews I did, where my colleague and I, who we shared the article student, we took them out to lunch, and we did that with 4 people. And I think, if I'm remembering correctly, it's been about 9 months now, but I think the other 3 were all from UBC, or 2 were from UBC Law, 1 was from UVic Law, and then only my student Zoe was internationally trained. But it didn't even factor in, because again, that doesn't matter to us. What we're looking for is, do you have the personality type to do it? Do you have experience that is going to give you a skill set that will translate into criminal law? And do you have the passion? At the end of the day, I don't care where you were educated, as long as you can show me that you've got the skills needed. That's all that matters.
Right. Is that something which is common for most lawyers?
I think so. Again, I can only speak to criminal law, because I do think the corporate firms have a very different opinion of things. But in criminal law, absolutely.
All right. Thank you.
You're welcome.
And so on the very final question, because I'm going to ask you both this, Mitch, you got your articling position through a friend, like through word of mouth, basically. Leeanne, did you advertise for an articling position, or did you kind of go the same kind of route? And if you were advertising, where were you advertising?
So I would say advertising in a sort of loose sense. Like, it's not like we took out an ad in the paper or anything like that, but I work for something called the Innocence Project out at UBC Law, which is, an international organization to help people sort of at their last resort of appeals. And they do a ton of work with the students at UBC Law, as well as the students at UVic. And so I emailed the head of that program with my little bulletin and said, disseminate this to your students. So all the UBC and UVic law students got an email indicating that I was looking for an articling student. And then other than that, it was just word of mouth. So I basically let all my senior colleagues know, hey, I'm looking for an articled student, spread the word. And again, because it is such a sort of community that's built on word of mouth, that's really how you kind of get the word out there. And everybody sort of knows somebody who's in law school, or everybody knows somebody who's a prof at a law school, and just kind of spreads the word that way.
That's a fantastic way to end this, because this is what I keep telling people. It's all about your network. So especially for those of you who are coming with an ITL background, you need to make those connections, because you never know who is looking for somebody, whether it's a new colleague that they're looking for, or whether it's potentially a new client for you in the future. Mitch, Leeanne, thank you both so much for giving up your time this evening. I have learned an awful lot about the criminal bar. Having been a solicitor in the UK, I never had to do anything to do with courts ever. So this is a real eye-opener for me. I literally just did the criminal and civil lit exams that I had to take. So this has been great. Hopefully for everyone else on the call, this has been super useful. I will, as always, put the video up on our YouTube channel. I'll also include the LinkedIn links for Mitch and Leeanne if anyone has any further questions. You guys can reach out to them. But don't forget, join us next week. We have another exciting topic who I can't remember who it even is off the top of my head right now, but you will find it on our LinkedIn page and on our Facebook pages. And we'll see you all next week. Thanks very much, guys. Have a great evening.
Thank you.
Everyone.
Take care, everybody.